Keith Mohammed of the Federal High Court, Port Harcourt, today nullified 16 House of Assembly candidates of APC in the state. And yes, it was the PDP in Rivers State that filed that suit against INEC and against the APC. And by the way, there are several other suits filed by the PDP against other political parties here in Rivers State. We have the one where I think the Rivers State PDP has gone to court against a Accord Party, against Labour Party, against SDP, I think, as well. Maybe just about every party, really, or including the APC, definitely, here in Rivers State. But joining me for this conversation right now is lawyer Henry Ekine. He's a national legal advisor with the Committee for the Defense of Human Rights. Henry, good evening to you. Welcome to Hard Facts.
Thank you. Thank you for having me.
All right. I'm just going to go straight and ask you. Hello, Henry. Could you turn off your radio set, please? All right, great. Thank you. So I'm just going to go straight ahead and ask you. I'm just going to go straight ahead and ask you maybe the most important question as far as this conversation is concerned, or definitely one of the most important or crucial, I suppose. Can a political party sue another political party, which in the case of the APC filing case matters against the PDP? I do concede I am not entirely certain as to the entire fact of the matter, but I do know from the reports we've got that in delivering judgment, the judge said it amounts to interference, that the political party, in this case the APC, cannot file a case against another political party as regards its internal affairs, that amounts to an interference. So, on that basis, and I believe it was also on that basis, maybe not entirely on that basis, but added to the list of bases on which the judge arrived at the decision of court. Now, that said, back to my question, can a political party sue another political party as regards the actions within that other party?
It will not be a straight answer, but there will be circumstances that, as associations that are registered and as official persons, two or more political parties may have transactions or get into some relationship that one may have a cause of action against the other. But in the context of the subject for the decision that we're analyzing here, there are circumstances that certain activities of political parties are considered internal and intra-party matters, to the extent that not only other political parties would not have the locus to sue the other political party, not even the courts will have the power, that is the jurisdiction, to entertain matters in those areas that have got to do with the absolute internal intra-party issues. So, in this on this background, one would say that there may be circumstances that a political party can sue another. They may get into some contract, they may get into some agreements, and then some party may breach some of those elements or clauses in those agreements. But principally, it is within the purview of the activities of political parties that have been identified by law or held by decisions of court to be matters that are internal. Then not any political party can interfere, not even a court can interfere in those internal matters.
Now, that said, or if that's the case, does the PDP suit, and as I mentioned a while ago, the PDP has, in Rivers State, has filed cases against possibly every other political party that exists in Rivers State. These matters have been heard. In a number of them, judgments have been delivered, usually in favor of the PDP. I'm not sure in any case that judgment has been delivered. It was not delivered in favor of PDP. And by the way, I am not questioning those rulings of the court. We're not x-raying those rulings. That's not the essence of this conversation. However, to my question, does the PDP, considering the answer you gave me just a while ago, does the PDP suit against other parties concerning their internal affairs, the internal workings of those parties, do those actions constitute an illegal interference into the internal happenings or workings of those other political parties, including the APC?
That's what it will be. Any political party, whether it is PDP or Labour Party or Accord, interfering in matters that are within the purview of the political party, it will be unworthy and, of course, not as acceptable. That's to say that this is what worries me. Except those matters that are subsisting, being a lawyer, I will say that those matters that are sub judice, I do not know. But for the ones that have been decided, it is really worrisome that the same court, and I mean the Federal High Court, would have considered certain political parties, precisely the PDP, of interfering, even when the other political parties have complained and cried that the PDP have interfered in their internal matters, so how they dealt with their personal issues and their party issues. And the court has allowed these matters to go on. The court has assumed jurisdiction, and like you said, has even delivered judgments or rulings in favor of the PDP in some of these matters that have this kind of resemblance of interference in the activities of other political parties. And then this time, now let me quickly say that when I read and looked at about 3 issues the court considered to justify the ruling of the court dismissing the suit of the APC against the PDP, if the court ended, as a lawyer, and of course judges are also lawyers because they were lawyers for the judges, if the court ended with respect to the court with the issue of statute bars, that is to say the matter was instituted outside of the threshold of the period that is allowed for any person to complain, that would have been clearly understandable because where statute provides the time within which you must complain if you have a cause of action and you slept over your rights and you didn't commence that action, it has the description of the matter being statute barred and the court will not have jurisdiction. That's clear. When you go further to say there was no cause of action, that's also clear. Cause of action would mean the right to institute a suit or the claim of any injury or pain that you would suffer by the action of the other person. Now, if you file a suit and you never disclose or show any reasonable cause of action that the court can ground its finding and make a decision, that suit is also not competent, and then the court will also not have jurisdiction. But it becomes worrisome when the thought is that, at this time, it appears that, although it appears anymore, because it has been held, that the All Progressives Congress have interfered into the internal affairs of the PDP. What is this internal affair? Is it about the candidates of the PDP or the other candidates, I think the governorship candidates or even the House Assembly or National Assembly candidates in the 2 decisions that have been delivered? Then one would worry, how different is this? It's about this of the APC as to how they are smaller and quite small. I will not be different. Like just cost money. That is what I come it was to give one of the story of the. So first, one would have this is what with respect to the lawyers that actually brought these matters, and then even what prayers are made before the court, and even the arguments that are canvassed. These are some of the other indicators that may probably sway a judgment or the other direction.
I totally, align with your position on that. Even though my alignment with you or not is not relevant, as I am not as I am not a learned fellow. However, it does seem logical to me, even though I am not learned. I dismiss it or not or for several reasons. However, and I'm being careful here that this conversation is an interrogation of the PDP or not, because like you rightly said.
When it has been delivered, we can interrogate the quality of the judgment. When the judgment has been delivered,
I totally get that. We can, and we've done that several. You and I have. I've had in the studio severally. We've done that. But what I find curious about this matter is not necessarily the judgment of the courts, whether it's in the party or the partner. The judge made mention that the APC was interfering in another party's matter. And it cannot do that. Now, if for the judge, for the judge to have mentioned that, am I right in stating then that the judge considered it a significant part or a part of the reasons as to why the court reached the decision that it reached. But before you answer that, Henry, we do have some show that when we continue to stick around. We'll face at the page. You've got the headlines come up bottom of the hour at 5:30 p.m. Discussion to that. still had Fact to Nigeria Info here in Port Harcourt, the number one talk station. I'm Dyer. Conversation continues. Court dismisses another APC suit against Rivers PDP. Federal High Court in Port Harcourt, where yet another suit filed by the APC in Rivers State has been dismissed. This time it was a suit challenging the competence of the PDP to field its House of Assembly candidate for the 2023 election. Justice Emmanuel Obidi dismissed the suit for lack of jurisdiction, adding that the APC has no legal right to interfere in the internal affairs of the PDP. Of course, interestingly, the PDP in Rivers State, using the choice of words of the court, has been interfering in the internal affairs of just about every other political party possibly in Rivers State. And just today, Justice Turaki of the Federal Court Port Harcourt nullified 16 House of Assembly candidates of the APC in Rivers State. The PDP in the state had filed a suit against INEC and the APC and its 32 House of Assembly candidates, alleging their congresses were not monitored by INEC. I'm asking you once again, and this is a matter of perception, by the way. What is your perception on the matter? What is the perception on other parties securing fair judgments in suits against PDP in Rivers State? My guest has joined me once again is Ekine, lawyer, national legal advisor with CDHR. Henry, you're welcome back.
Yes, thank you, Darren.
All right, so to the question I asked you before the break, whilst, we may at another time interrogate the quality of this judgment. However, maybe that's not the entire essence. However, if you need to do that to make a point, it's very well for you to do that. However, if the court is saying, what I find curious, as I mentioned earlier on, is that added to these other reasons that the court has said is the reason it is dismissing or has dismissed APC's suit, the court also added that the APC's actions amounts to interfering in the internal workings of the PDP. Now, can that be said to be one of the bases on which the court reached its decision?
Yes, that's what the court has said. What has been reported as what the court has said includes that. And when the court delivers judgment and then gives the reasons for delivering the judgment, apart from the side comments that the court may have made, that is the judge, otherwise every other issue that was considered that led to that decision one way or the other is a significant issue that formed the basis of the opinion of the court. So in legal parlance, we have mere references and then the other comments by court that actually made the decision. I don't want to bore our listeners with what those references really are, but there's a distinction. So in this context, where the judge has mentioned the various considered issues that led to the decision to the effect that the matter has been dismissed, that it's reported that it includes the fact that the APC was interfering in the internal affairs of the PDP. The question that will be asked may probably be, what is that interference? And what are the various elements of interference? How is this one interference when, like you read earlier, questioning what perhaps the chairman of the PDP didn't do, that was probably required to do or didn't do properly? If another party cannot have the competence to question that, how much will another party have the competence to question the process of emergence of candidates of another political party? Beyond that, even how the primaries of another political party are conducted. And the Electoral Act is clear, except that sometimes we turn away deliberately with some purpose from the provisions of the law. I can tell you in some of the matters that have actually come up, just permit me, that the National Assembly has even clearly demonstrated the intention that there are internal affairs of political parties, to the extent that the National Assembly, in enacting the Electoral Act, focused on the primaries, because that is where candidates will emerge to run for positions that are created in the Constitution, and left the other internal issues as to how delegates will be constituted to lead to primaries, to political parties, to be addressed in their guidelines and in their constitutions. But today, sometimes you find that matters that pertain to how delegates will be elected are entertained by court. Matters that pertain to even elections of executive members of political parties are entertained by court, not necessarily brought by members of the political parties that agreed. Take, for instance, this particular issue of candidates that are being now disqualified by the courts and the threat to our democracy, I must say. That is not to say that the courts are not entitled to examine the procedures in compliance with the Constitution and with law. But where we get to a point where candidates are being disqualified almost every day in the sequence this time, I think we have to be very careful how this may affect our democracy. And again, I believe it affect the rights of citizens to freely choose who represents them, as a matter of fact. So I would say that the fact that the judge mentioned that as reported, then it forms part of the issues the courts considered and have said so. Nobody forced the judge to say so, to include this particular one. Like I said earlier, if the court, to my understanding, if the court had actually stopped at the issue of statute bar, any matter that is brought outside of the threshold of a period, if statute has provided, 14 days from the date the cause of action arose, you simply will look at the date on the process, the originating process, and look at the date that the cause of action arose, and you will know that it's outside of the 14 days. Clearly, that matter is incompetent. And you look at it probably where the court itself is not properly constituted in terms of number or in terms of the spread, the range of its power. You will say it doesn't have the jurisdiction to entertain that matter. But when it comes to these issues that are clear in the law, like I said earlier, one may have to probably look deeper into what the content of the processes that were filed and exchanged really were.
Now, not only the APC is involved in this, as I've mentioned already, even other political parties as well. The PDP has filed cases, like I said earlier, against possibly every other political party in Rivers State. In some of those matters, judgments have been delivered. Some judgments are being expected. Now, those other parties, including the APC, can they appeal? Is there still enough time to appeal these rulings on the grounds that it amounts to an interference in their internal party workings by the PDP? And do they still have enough time for these appeals as the elections are drawing closer?
Yes, they do have. That was deliberate. That was why the new Electoral Act 2022 and even the guideline, the schedule of activities by INEC enables political parties to have their primaries so early this year, and then to give room for all of this. So the political parties still have the window to appeal it to the Supreme Court. And I remember that there are regulations and there are guidelines and even practice direction as to how to handle election matters by the courts. Election matters are given priority here now, and they are given a practice direction and directive by the Federal High Court, which is where most of these actions are filed, to pay attention and focus on election matters, the pre-election matters. So I'm not afraid that the time is not sufficient or available for these agreed parties. The time is still there, even not to the Supreme Court. Even the courts are guided as to the period within which they must hear and determine election matters. So these are already provided. Now, let me quickly bring up something that I found now.
Go ahead.
You see, even in complaining about the procedure during primaries for political parties and the emergence of the candidates, it will surprise some that are listening. And it should be by the person, the party, the aspirant in that context who is agreed with that procedure that should come to complain. So sometimes one wonders how and from where will another political party have the competence to question the procedure and manner of the primaries of another political party and how a candidate emerged. Even when that process was not in compliance with the provisions of the Electoral Act, it should be an agreed person, an aspirant in that process that should complain. I'm not speaking out of the Electoral Act, but I wonder how I don't know, maybe I am not all-knowing, whether there is any window anywhere that has come to enable political parties to question the emergence of delegates or even of aspirants stage that political parties are conducting their primaries, whether by consensus or by direct or by indirect, as the Electoral Act has provided now, is an internal affair of the political parties. Because all that will be qualified are members of the political parties, but they are aspirants. It is only until when they become candidates, that's when they will contest with candidates of other political parties. But we will continue to examine all of these dialogues.
The lines are open right now. Join the conversation. Call 0700 923 0923. That's 0700 923 0923. We're live on facebook.com/NigeriaInfoPH. We're also live on Twitter at NigeriaInfoPH. Let's get your take on the matter. I've got several comments here already via Facebook and Twitter. Everbright Amadi on Facebook goes, the court didn't do any reasonable justice. The court just did a miscarriage of justice. Christian Humphrey goes, well, this very judgment surprised me. How come and what is the net measurement for accepting one and rejecting the others? Could it be that the APC sins have gotten to God? Ned Aguma goes, the presiding judge specifically said that he was relying on the fact that the APC was not supposed to interfere in the internal matters of other political parties, hence in favor of the PDP. But my worry is that just the PDP got favorable judgment against the APC in the same case brought by them. Please, I need enlightenment here. Good news, Uwan goes, why is the PDP taking all other political parties to court? Why? It's because they know River State can be put by PDP. All right. Also, let's say. All right, to some other comments now. Indebisi Amadi goes, what do people understand by politics? Judiciary is controlled by the government in power, so APC no way in the state. Ransom Patrick goes, River State Judiciary should try to redeem their spoiled image. Kandu and Yali Libechi goes, shopping for judgment against another political party will make the benefactor not to own a common manifesto. It is disheartening that the court of law will decline jurisdiction when the matter comes, but later assume jurisdiction when it comes through another door. The judges are mocking democracy. Ricky Brown goes, I'm tired of Rivers judiciary. When you talk, some will say CRA is paying for what he did. See, the truth is, instead of this one-sided, partial, unjustified and unbalanced judiciary, it's better to be closed. I mean, what is this? One party don't have a right for another party's internal affairs, but the other party has and can be victorious. This is hilarious. Once again, number to call, 0700 923 0923. That's 0700 923 0923. I have a problem with the Chief Justice of Rivers State. People see the state judiciary as a place where cases are traded and that the arm of government is in the hip pocket of the governor. When he was in law school, where was the governor that he'll be doing this with the governor? That's Mandy. All right, thank you, Barrister Ekine. You're doing a good job. Please, can the APC appeal this judgment? And if they can, which court? Is there enough time? That's from a BBFI man. I did ask Henry that a similar question, possibly even the exact same question earlier on. So I hope you caught that to BBA. This is just another example of us borrowing things from other countries, such as a legal system, turning it upside down and becoming a laughingstock. The earlier we start telling our judges the truth, condemning the corruption we see that is destroying our democracy, the better for us. What is going on in this state, where the governor is known to lavish the judiciary with gifts, cash and houses, is that there is now a separate rule for the PDP and another set of rules for other political parties, where the PDP gets all it wants and never loses. It's a big shame and would help the state. Again, lines open, 0700 923 0923. That's 0700 923 0923. And Frank says, Nigeria is confusing. Diane, please ask your guest, is there any possibility for a political party, after having primaries, set a court injunction stopping any other political party from interfering into their primaries? Harry, I'm not sure I understand your question. Maybe if you can rephrase it, and I understand it, then I'll ask Henry. But I think we've got a call coming in now. Agbona is on the line from Imo State, I think. Agbona from Imo State, you're welcome. Please go ahead.
Yeah, good evening, Dayo.
Go ahead, please.
Yeah. Please, my dear brother, what is happening in our judiciary, especially in River State, the thing is beginning to baffle me, I must confess.
Oh, my. I'm going to manage to call back. Good evening. Sometimes we don't know how these judges emerge. Don't they hear other same cases of the matter? The management of the courts must look into all these judges. Honestly, they need to be questioned. That's from Morgan. Now, Henry, I need to ask you this. If indeed there is a problem, and to borrow the expression you were going to or did not borrow earlier on, the former president Obasanjo's comment, famous K-leg, if I may borrow that expression, if and that's a big if, by the way, if there is a K-leg with the position of the court on this matter, that the other parties, the APC is interfering but PDP is not interfering, is there any recourse? Is there any resetting, within the judiciary that can address this, if indeed an injustice has been done? But before you respond to that, we've got Brown on the line from Enika. Brown, you're welcome. Go ahead.
Thank you, Dayo.
Go ahead.
This is another thing. This is very painful in River State. This is very painful. To see all these things happening. I said it when the governor was buying all the cars and giving nothing for judges, that this will happen. Now, it is happening. This is shameful. The River State judiciary has become a laughing stock of the world, not even of Nigeria, but of the world. I thank you, sir.
You're welcome. So, Henry, could you respond to the question, please? Does the judiciary have any self-correcting mechanism or system if indeed there is a K-leg with this position of the court?
Now, the difference between this and Obasanjo's remark is that this is a decision of court. And the one straight way to express your dissatisfaction to any judgment or ruling of the court is appeal. So what's valuable for the dissatisfied parties here now is actually to appeal against the decisions of these courts, the Federal High Court, and then to the Court of Appeal. And if you're still dissatisfied, if the judgment is not overturned, then you go to the Supreme Court. But if you're fortunate and the Court of Appeal is overturned, then of course you will have expressed. But when it comes to, if it is about the infraction of the conduct of judicial officers, if that's the intention, then of course we have the National Judicial Council, that is the federal body for discipline of erring judicial officers, if it is seen in that regard. But this isn't quite in that context, because when a judge has dispassionately to the court's conviction, I haven't heard a matter, and that's the finding of the court is entitled to its finding and then delivers a judgment. The court is functions official on that. As delivered that judgment is done with that matter at that level. If you are dissatisfied, go upstairs. So that's practically what it is. But let me say something very quickly in 1 second. I made reference to primary. That as it is now, the Electoral Act 2022, the only section, a long one, that provides with respect to nomination of candidates. That is all these issues about procedure and processes for primaries, whether it's direct, indirect, or by consensus, and the compliance with the Electoral Act or the Constitution or even the guidelines of a political party are provided under Section 84 of the Constitution. And it's so carefully done to the extent that it has about 15 subsections. And what will give us an indication to what I stated earlier is subsection 14 of that Section 84. And if you read that, it will suppose that it's aspirants in the political party primary that should complain. It says this, that notwithstanding the provisions of this Act, that is the Electoral Act 2022, or rules of the political party, an aspirant aspirants who complain.
Henry, I apologize, Henry, but we have run out of time, and I must wrap this up right now. Thanks for joining us. Henry is lawyer, National Legal Advisor, CDHR. Henry, thanks for your time.
Stay with us. Nigeria Info will be